We're going to have Anna take us through that bill draft as it is presented today, and then the committee can move forward as they see fit. Go ahead, Anna.
Thank you, Madam Chairman. This bill draft is entitled 25 LSO 113, Federal Land Use Plans Legal Action Authorized. This bill draft amends Wyoming Statute 28.8.114, beginning on the top of page 2. The bill draft declares that the legislature has a sufficient interest in the proper interpretation and administration of several environmental federal acts, which provides the legislature standing to prosecute an action for declaratory judgment to protect its interests and the interests of the public. In subsection C on page 3, the draft indicates that the legislature shall have standing and may use funds for litigation purposes to prosecute actions for a declaratory judgment. And then the staff comment on page 4 indicates that the bill draft originally had management council borrowing funds from the LISRA to fund litigation. That method is probably not feasible. It was suggested that the draft should create an account and have an appropriation that won't revert at the end of the biennium. So in subsection F on page 4, that indicates that management council may utilize funds from the federal land use plan litigation account created by this bill draft. And management council may utilize up to $50 million at any one time. Subsection G on page 5 creates the federal land use plan litigation account. And then section 2 on page 6 provides an appropriation of $50 million to the account created by this draft. Section 3 on page 6 provides for an effective date. And I would stand for any questions.
All right, any questions, committee? Senator Ide.
Thank you, Madam Chair. My first question is, this was the bill draft that we started with, and it's not the engrossed version of the bill that we passed in both chambers that got vetoed. So I'm not sure if we're working off of this bill draft or what we already passed last session. Thank you, Madam Chair.
Madam Chair, Senator Ide, I believe this is the enrolled version. So I believe it went through the Senate and then it had a lot of changes in the House. So we're working on the bill that went halfway through the process.
All right. Question answered. Thank you, Senator Ide. And by the way, before we go on any farther, I just did want to recognize Representative-elect Bratton, who is joining us today. Welcome, and we look forward to working with you. All right. Are there any further questions for staff? Oh, we also have Majority Floor Leader Nyman here. We'll be getting to him soon, but we want to recognize you. Didn't mean to be remiss in that. Thank you. All right. Any further questions for staff? Seeing none, we will take public comment on the bill draft. Any public comment? Public comment? Any online public comment? Seeing none. Committee, what's your pleasure?
Bill.
Moved by Banks, seconded by Ide. Are there any amendments to the bill? Any amendments? Go ahead, Senator Ide.
Thank you, Madam Chair. I'm not sure if we want to, this is a little bit of new territory for me. Do we want to try to bring the amendments to that the House brought to this bill that we voted on last session back into this bill and move that appropriation back up to 75 million from 50 million? That's where we were. So if you can help me out with that, Madam Chair, thank you.
Senator Ide, is that a motion or just a discussion item? Are you moving to amend to 75 million?
Madam Chair, thank you. I would make a motion to move that back to 75 million or move it up to 75 million. However.
All right. Is there a second?
Thank you.
It's been moved by Ide, seconded by Allemond. Discussion? Discussion on the amendment. Senator Kolb.
Yeah, thank you, Madam Chairman. Would you want to add in there was more language in the House version that would, I mean, if you want to add that in, would you? I mean, I would think we could do that in a motion just turn it back into the bill that came out of the House that was vetoed. It added in the Board of County Commissioners as people that could utilize those funds for fighting the federal government. It was a question to the bringer of the amendment, if you want to.
Why don't we do it this way,
Separate, right?
Senator Kolb, let's do those as two separate amendments.
Okay.
First, let's vote on the raising it to 75 million, and then we'll vote on the separate motion if you would like to make that afterward. Is there any discussion on the $75 million?
Madam Chairman,
Senator Hicks,
the alternate scheme that we could possibly contemplate is rather than designate an actual dollar amount, because that puts limitations, number one, on how much you could actually expend out of the account. And I'm trying to think if we've ever done this anywhere. I know we have for the executive branch, but I use the terminology as spending authority. And so what I'd like to do is, rather than just say, what I want to do is leave it open-ended. And so if we only need 5 million, we need 5 million. If we need 80 million, we need 80 million. And so typically the way we would structure something that would say that the legislature may utilize any funds from the LSRA for the purposes of litigation as approved by, and I'd have to go back and refresh my name on the rest of the bill, as to whether we do that through an act of management council, because primarily what we're looking at is hiring legal help to represent the legislature. We do this already with the school finance program, where we retain a certain budget within the legislators in our own budget to hire consultants to do that. So what I'm thinking more of is we may want to craft that language such that we can spend whatever we need versus just specify an amount in there. And as long as there's money in that account, we can tap into it. That would be my preference, is to look at how we would craft that. We'd have to work with budget and fiscal and look at that. And then how do you tap into that? My preference again would be is because we may want to do this sometime when we're not in session. And rather than wait a year, is that would take an action by management council to authorize the hiring of legal representation for the legislature. And basically what we're doing is we're giving ourselves borrowing authority to whatever amount that we determine is needed for the purpose. In other words, it just doesn't appropriate. The minute that we put that language, appropriate $50 million, that kind of earmarks that pot of money. And the way we've currently got the LSRA structured, some of that's pretty much liquid assets. Because we do that, we say we've appropriated that money. State Treasurer's Office has no idea when we may going to utilize that money. And so when you jack that number up, it puts a little bit of headwinds against our potential for investing for a higher rate of return. And so because we've already got that bifurcated account in there, what they would just roll anything that said we might want to use for legal representation, that would maintain in that more liquid portion of the LSRA. But every time we appropriate money out of there and set it for a special use, they're going to put a little more money in there. And what I'd rather do is say, to the extent possible, the legislature can utilize funds out of the LSRA for the purposes of hiring legal consultants for the purpose of litigation, or experts. May not necessarily, quote, be a legal expert, but it just basically would provide us the borrowing authority to go in there and expend that with the approval of most likely management council. But anyway, just a thought, Madam Chairman.
all right, thank you, Senator Hicks. So Anna, my question would be, on page 4, subsection F, lines 22 and 23, the management council on behalf of the legislature is authorized to utilize funds from the federal land use plan litigation. What if we said from the LSRA? We had it that way in the past. Then we have a staff note that says we can't borrow from the LSRA, but what if we give them spending authority from the LSRA? What's the difference what account it comes from?
Madam Chairman, I'm not an expert on the LSRA. But as far as like using funds from it in that manner, I don't think that that would necessarily be a problem because you'd be taking, I mean, I don't think it makes a whole lot of difference which account you necessarily take it from unless there's something in the LISR that says it can only be used for certain purposes. So that's the only thing I'd be worried about. But I mean, I think you probably could change that language just to say that they can take money out of the account.
Senator Hicks, go ahead.
One of the things we need to do is simplify and get rid of all the coffee cans. This creates another coffee can that 5 years down the road, nobody here remembers that coffee can exists and it's putting tailwinds on and investment strategies and stuff. It's just better to leave the account the way it is and then provide the authority to expend out of that account for this purpose. There's no
Okay.
more created accounts. It's simplified.
I understand. So right now we're talking about the amount of the 75 million. That's what the amendment was for. And would we, Senator, do you still want to have basically a cap that it's 75 million is what if we did choose to do this, here we'd create a separate account. That sets the amount that they're able to utilize up to. Because that's what the language is, up to, not to exceed. So go ahead, Senator Ide.
Thank you, Madam Chair. You know, I think when we originally drafted this bill, I think 75 million is, far and away what we would ever need on this. It was more of a lot of it was a statement to the BLM that we're serious about the persecution that we're getting in our state on our natural resources, and we're going to fight it. And I think that, the language that was amended in the House on this actually stated that we would borrow the money from LISRA. That way we're not setting the money up in a separate account.
Right.
And I like that version. I think Ben Larson might want to comment on that as well. Thank you, Madam Chair.
All right, Senator Larson.
Madam Chairwoman, I think the engrossed version that went to the governor deals with all this. Is that not what everyone's, I think Barry's shaking his head to.
Yeah.
Representative Grego.
Madam Chairman, just for clarification, borrow means something different than
The
spend.
next spend. That was
Borrowing
the
infers that
problem.
you're going to pay it back. It's subtle, but it's important. Are you going to borrow the money? And then the connotation is there's an obligation to pay that back. What I'm saying is we're just going to spend out of the LSRA for this purpose. That's what I'm trying to get at.
And just for reference, I think that that's what we have spending authority to litigate on school finance. So it makes it better. Go ahead. Representative Craigo.
Thank you, Madam Chairman. I think everybody's on the same page. I think we could take the enrolled act from last year and change the word borrow literally to expend and leave the rest of the bill draft the same. Because if we go any further than that, to Senator Hicks's point, then we don't even need the rest of that bill, because then we can expend it anyways. I think if we want to do what we're all wanting to do, which is make a point, make sure everybody knows that we're willing to do this, then you just change the word borrow in last year's bill draft or the actual enrolled act from borrow to expend. And then I think that covers your concerns and covers Senator Ide's concerns, and everybody's in the same place.
Representative Craigo, could you read that subsection?
Sure. So that is section F, and it said the management council on behalf of the legislature is authorized to borrow from the legislative stabilization reserve account an amount not to exceed $75 million at any one time to take any of the actions specified. Sorry, I got to change page in this section. Funds borrowed under this subsection shall be in accordance with the following, which we could get rid of all of that if we're just if we're just giving ourselves the ability to expend,
All
I
right.
believe.
Anna, have you got that?
So,
So
Madam
what are
Chairman,
we?
just to get to Senator Hyde's point and Representative Kratos, if you want to send a message, now you have available at your disposal based on the last profile, $1.8 billion that you could expend for this purpose. I mean, if you really want to make a point, that's a lot more money than 75 million.
Senator Ide, would you consider that a friendly amendment to your motion?
Thank you, Madam Chair. I think the discussion would be good from everybody on that, but I don't really see a problem with that. I mean, that gives us sort of a carte blanche on what we want to do here. Thank you.
Senator Cold?
Thank you, Madam Chairman. Yeah, I think it has a lot more weight to it because the fund's a lot larger. So if we're trying to send a message, this is a lot larger message. And so that's why I'm in favor of changing the language to cut out the 75 million and just keep it the Lister account. Thank you.
Senator, or Representative Crago, I keep calling you Senator already. Go
Thank you,
ahead.
Madam Chairman. I guess I probably disagree with that. Excuse me. The reason being is there will not be a dollar amount in the bill. And so no one's going to take the time to go look up LISRA and see what the balance is on that particular day. So I think you lose a great deal of your effect. If that is one of your points of passing the bill as an effect, no one's going to go look up LISRA, but they're dang sure going to see that it says 75 million within the bill draft. Great.
All right, so here, we have a motion on the floor of the 75 million. So we need to deal with
Yeah,
that
somebody will.
first. Our conversation has taken us on a rabbit trail. As chairman, I'm going to rule that we are going to vote on whether we want to put the cap of 75 million or leave it at 50 million, and then we can deal with the rest of it after that. So, is there any more discussion on the amount? Go ahead, Senator Ide.
Thank you, Madam Chair. Not to belabor this, but both points are good. I mean, I agree with both of the arguments on this. I guess we move forward on the 75 million like you recommended, and we'll go from there. But
Yep.
thank you.
And remember, in voting in this committee, we adopted rules that it has to be a majority of both bodies. So as we vote, remember that. So now, seeing no further discussion, all those in favor of raising the amount to 75 million, please say aye. Opposed, no. That passes. So we're back on the bill. Are there any further amendments on the bill? Further amendments on the bill, Senator Ide.
Thank you, Madam Chair. I've just got been looking at this thing ever since it got vetoed, and there's a few semantics in here that I think would be appropriate. On page 3, line 1, says the legislature to prosecute an action. I propose to amend taking out after prosecute, taking out and putting action, put an S behind action is action. So to prosecute actions for declaratory judgment.
All right, and could I get a second on that?
Yeah.
It's moved by Ide, seconded by French. Any discussion? Discussion on the amendment? Seeing none, all those in favor, please say aye.
Aye.
Opposed, no. That has passed. Further amendments, Senator Ide. Turn on your mic.
Thank you, Madam Chair. On page 4, line 4, I think it would sound a little bit better. That whole paragraph reads, the legislature or the management council may direct the legal staff of the legislative service office to commence and prosecute and action, replace the with an. Thank you.
Okay.
I moved to make that amendment.
Been moved by Ide, seconded by Slagle. Discussion on the amendment. All those in favor, please say aye. Oh, never, did you have discussion? An LSO question. Anna, go ahead.
It was a question about the phrase, changing the phrase as amended. Is that legally cause us any issue?
Go ahead.
Can you expound on that a little bit? Are you worried about changing the to an or,
The last motion, Anna.
okay,
Changing the word the to an, prosecute an action.
I think it'd be fine.
Okay, are we good? Back to voting. All those in favor, please say aye.
Aye.
Opposed, no. That motion passes. Further amendments on the bill? Any further? Senator Fold.
Thank you, Madam Chairman. To incorporate the language that came out of the engrossed version or I guess it would be the engrossed version that came out, went to the governor's desk that included, in this case, money that could be used by in one particular case, by the Board of County Commissioners, to prosecute, actions against, federal resource RMPs and alike. So to put that language back in again, as I understood it, the motion that we had before was only to deal with the 50 million to the 75 million, and some language changes. And I have a discussion about basically making it the same bill minus some of these changes we just had that the governor vetoed.
All right, so there's a motion on the floor to add the county commissioners to be able to access the account to expend these funds. Is there a second on the motion? Second on the motion? Second by Davis, moved by Kolb. Discussion on the motion. Senator Ide.
Thank you, Madam Chair. I'm a little bit, I guess, agnostic about that. That was added in the House. And I'm not sure if we want to be spreading this around to all of the the counties and stuff like that, making this messy. Number one, that language in there really doesn't explain how the county pays that back either. That's one of the questions I have on adding that language in there. And do they pay it back with interest or where does that go? So at this point, I'm a no vote, I guess, of the way the language is written right now. Thank you, Madam Chair.
All right, Anna has some insight for us. Go ahead, Anna.
Thank you, Madam Chairman. I'm trying to remember, but I know there's probably some constitutional issues regarding giving money to the county commissioners to initiate these lawsuits as well. I just can't remember off the top of my head what the specific issues were, but I know there was some concern about having that language in there when we first brought this bill back. So I just wanted the committee to be aware. I can find more information if you need me to. I'm just putting that out there.
And there's another account within the governor's office that I believe they have
It
some
was,
access
yeah.
to, and so Senator Kolb.
Yeah, thank you, Madam Chair. Yeah, there's the FERNOPA account. The issue we're having is they're not, the governor is not paying out of the account for expenses, particularly in my county. They have pending requests for reimbursement, and it has not been reimbursed. This bill originally came out to be, an issue for the legislative body to have the ability to represent ourselves as somebody was standing dealing with the federal government. The Board of County Commissioners, to be clear, have standing. They have a whole separate, clearly defined standing, as opposed to, frankly, us. It's a little different. That's the reason why it was broadened up. I'm not going to die on this hill because of this. So, if it doesn't work, it doesn't work. I just thought we had something that House and Senate both agreed to. It went through the process, and the stumbling point was the governor's veto. So I thought maybe if we construct the bills in a similar way than it left to the governor, the more easily it would make it through the process. And that's the reason why I brought the amendment, but vote it up or vote it down.
Thank you, Senator Kolb. And if this vote doesn't go your way, there might be other ways to address your concerns with your county commissioners, and we'd be willing to look into that. All right. Any further discussion? Further
Madam
discussion?
Chairman,
Go ahead, Senator Hicks.
I'm just curious as to how many staff we're going to plan on hiring once we start it, because right now, the way this is structured, it says the management council would basically authorize those contracts on behalf of the legislature. Now you have to have somebody to take application from the county, review those applications, make a recommendation back to management council. I'm assuming that's the way the process, or do we just, the question would become, do we just fund those but it's going to take more internal time to do that if that's the direction you want to go. I'm just cognizant you're just putting more unspecified duties both on management council and LSO. If you want to go down that route, that's fine. Just be aware there's a time and personnel cost associated with a county submitting a request to management council for financial assistance to pursue an action associated with the federal land use plan. Or do you just hand the money out? And so, which comes back to maybe you got to write rules and policy on how we would do that. And then somebody's got to account for it. It sounds like a good idea, but the logistics of it have to be addressed. And so it's something that's out there. And I would concur, we already have an account called the FNRPA that does that. But also concur with my colleague from Sweetwater County that there's some significant problems and sometimes on how those are being. If we're going to want to look at that, that's a separate issue we ought to really take up and look at as to why are these not being, because we have that specifically for that purpose. That if there's problems there, we need to look at that and address those versus just create another program and then have two programs that have a dual purpose. That's my thoughts on the process. I think it's well worth something this committee may want to look at. I've heard this over and over again for the last number of years that there's processes getting problems paid by counties, even though so typically the FNRPA process, a county would apply for funding to the governor's office for those FNRPA funds. Those are reviewed and approved. And then once you've got those funds approved and you use those and you go out and you hire your expert witnesses and your legal advisors and all that stuff to help put together your comments on those federal land use plans. And then there just seems to be a bottleneck, even though it was approved, why are they not getting paid in a timely fashion? And how that, if that's the issue, we ought to look at that separate versus stand up another program. That's my opinion.
Representative Banks.
Madam Chairman, thank you. If I recall from last session, I don't think that this amendment was all that popular. I think it didn't pass by a big majority in the House. And like Senator Ide, I'm not totally against it, totally for it. But I think the goal was to come out with a solid piece of legislation that gives the legislature a tool, because we don't have a tool in the toolbox like the rest of these agencies have. And so I think going forward, we wanted to send a message to the federal government that the legislature is serious about this, but we also wanted to give ourselves a tool. And I think how it's written now gives us the best avenue to do that. So I, at this point, think I'll be a no vote on the amendment.
All right. Any further discussion at the risk of having some? Okay, seeing none, all those in favor of adding the county commissioners to the legislation, please say aye.
Aye.
Opposed, no. I believe the noes have it, but if you're an aye, please raise your hand. Just to make sure. 2, 3, 3 aye. Noes, raise your hand. To the rest of the noes, 3 outvoted by the rest of us. Okay, that fails. Are there any further amendments on the bill?
Madam Chairman,
Senator Hicks.
I just want to bring it to the attention of everybody, the way that this is currently structured. It requires 2/3 votes of management council to approve authorization. So 2 years ago, we restructured management council. It's made up of 10 individuals now, which is the leadership in both houses. So, and that means both parties. So you have already 2 members of the Democratic Party on there. And then you have the leadership in the House and the Senate on the Republican side, which is 3 and 3. And then you have 1 member at large. So under the current construct, you have to have a minimum of 7 votes to approve any expenditures out of this sub-account within the LSRA for the purposes of what the bill contemplates. That's a pretty high bar, folks. And so I'm just saying, if you're fine with getting 7 votes out of management council to prosecute this action for this purpose, leave it the way it is. If you're not comfortable with that, somebody needs to come up with another suggestion as to what that bar is. It may just be a majority of management council. I'm just throwing that out there. I'm not making that motion. I'm just bringing it to your attention. I think it's a probability that would never get authorized in management council when it only takes, 7 people actually to get that passed. That's my opinion.
Senator Kolb.
Thank you, Madam Chairman. Well, could I make the motion that we change it to a simple majority of management council?
It's been moved by Kolb, seconded by French. Discussion. Discussion on the amendment to make it a simple majority. Senator Ide.
Thank you, Madam Chair. I'm in favor of that motion. I think, the way the statute reads is if we're in session, it's a majority vote. But, most of these things are going to possibly happen afterwards. So we got to get closer to the prize here. And I think it's a good amendment. Amen. Thank you, Madam Chair.
All right. Representative Almond.
Thank you, Madam Chairman. And this is just a question. Can we make it that a tie vote is a winning vote instead of a tie vote being a losing vote? Is that possible?
I don't.
I was told
believe
it's not
so.
possible.
Yeah,
Thank
I
you.
don't believe so. All right. With that being said, and us not upending every rule that we have, is there any more discussion on this amendment? Senator French?
Thank you, Madam Chairman. Where in the bill would it state that?
Go ahead,
Page-
Senator Hicks, turn on your microphone so everybody
Page
knows what's
3,
going on.
line 7.
Page 3, line 7.
Oh, okay. Thank you.
Okay, all right. Everybody good with that? Okay, all those in favor of making it a simple majority vote of the management council to expend funds out of the LSRA up to $75 million without the commissioners, please say aye. Opposed, no? That new motion to all the other ones we just made that I recapped has passed. And we are back on the bill. Is there any further amending of the bill that you would like to do today? Senator Ide. Oh my gosh.
Thank you, Madam Chair. Sorry to belabor this. This is one of my priorities. So appreciate all of the
It's
extra.
not a belabor.
voice time
We're
here.
glad to do it.
All I really wanted to say is really not an amendment. I want to thank LSO staff, Anna, for writing that paper on separation of powers and give Tamara, is it Rivali? Is that how you pronounce her name? She's the one that discovered this statute when I asked the question of, is there any laws that gives the legislature standing to prosecute and bring action, and discovered that. The governor made what I thought was a weak argument that was a separation of powers, Mainly for the fact that this was already statute. So all we did was make a few amendments to it, but your comments were good and they were helpful. So thank you. Thank you, Madam Chair.
Thank you, Senator Ide. That was very worthwhile. I appreciate you doing that. And I appreciate Anna and our staff who many times gives us the argument that we will likely be up against on the floor with regard to a bill. So it's not meant in any way to discourage us from running the legislation, just to make us more educated on the entire process and other differing viewpoints than our own. So thank you for that. With that, do we need a roll call vote on the bill? All right, go ahead and take it away, Katie.
Madam Chairman, this is roll call vote for 25 LSO 0113, federal acts, legal actions authorized as amended. Senator French,
Aye.
Senator Hicks, Senator Ide,
Aye.
Senator Kolb,
Aye.
Senator Larson,
Aye.
Representative Allemand,
Aye.
Representative Allred,
Aye.
Representative Banks,
Aye.
Representative Conrad, excused, Representative Crago, Representative Davis,
Aye.
Representative Slagle,
Aye.
Representative Winter,
Aye.
Co-Chairman Eklund, Chairman Steinmetz,
Aye.
14 aye, 1 excused.
Thank you very much. That bill has passed. Good work, everyone. We'll give this one another shot. And with that, we do have one more item. I'll invite Majority Floor Leader Nyman and his sheriff to come forward. We are having a few issues I hear up in your area, and we're glad to hear about them today. So welcome to the Agriculture, State and Public Lands and Water Resources Committee. Thanks for making the trip over to visit with us about a situation that the committee, we have worked long and hard on state leases. And so we're very interested. So if you could please give us your name and where you're from and just take it away.
Sheriff Hodge, Crook County Sheriff, obviously, and Madam Chair, members of the committee, thank you for having us over here. Your time is valuable, so we could go on for quite some time with this. Madam Chair, would you like a brief history of how this all occurred?
Yes, please. So first of all, tell us the issue you're having, then take us into a brief history of how this all occurred. But tell us what we're talking about first. I haven't briefed the committee, and I know you sent a nice letter, but I wasn't going to pass that out unless you wanted it to go to the whole committee. And so go ahead and just brief us.
So currently, what we have is a state lease that lies in between private land ownership, federal land. And for 45 years, this is where the history a certain land or landowners leased this property that was private property. And in 2019, that property was sold to the state. It turned into a vacant land lease. So during the process, that's when emergency rules were put in place for 6 months, I believe. They got caught up in these emergency rules, lost these private landowners that originally leased the private land, lost that. And now we have a different individual. The boundaries on there, it's through a draw, where when they did estimates was between $340,000 and $380,000 to have it fenced. So none of it's been fenced. So now we have the original leasee that leased the bottom part that the state has now that leases to another. He also has the federal lease. So now we have intermingling cattle that are going back and forth between federal lease and the state lease. We cannot get a consistent answer from OSLI. OSLI stated to me that there's an exception to state lands having to fence out per Wyoming statute fence out law. They have never provided that statute. The only thing they provided in their last letter was to me was a trespass statute that you can be cited for trespassing on state land. So I'll go into the history. These original ones leased this private property for 45 years. They lost all of this per the emergency rules which allowed highest bidder to get the lease on the state land. No preference was given by state statute from 2019 to adjacent landowners or previous leaseholders. And so they were not previous leaseholders from the state, but they're adjacent landowners. So now we're in a absolute mess up there. We have two ranchers. There's another third that was involved, but they're minimal, that are fighting every week. We have deputies going to their houses. They're threatening each other. Well, not threatening each other. It's pretty much one-sided. The one that holds the state lease now is causing most of the issues. And so we have families that are fearing to go on to leases because they have to go through the state lease to get to some of the federal lease. And now we have to have cattle moving out. So it has turned into an absolute disaster. And I am looking for some type of resolution. I met with the governor, Representative Nyman, Senator Driscoll, and Interim Director Crowder. And their explanation was to let nature take its course. And that is just not an acceptable statement to me. Nature taking its course, we're going to end up with a bad deal down on that lease. Thank you, Madam Chair.
All right, thank you. And Representative Nyman, would you like to further comment?
Yes, thank you, Madam Chairman, and thank you, Mr. Chairman, for allowing us the opportunity to be able to come and address the committee today. I guess my position in it as representative is from a policy standpoint. And the problem that I have is when we first were made aware of this lease changing hands, I had a meeting with the top 5 electeds and asked them to please, by all means, let's get your new rules established before we make a determination on this. And please don't do this, because I had been on site, discussed at length with the landowners that were going to be affected by this, the problems that they could see coming with these pieces of parcels that were inside of their already private lands or unfenced. And so that change of that lease was going to create such a financial hardship. It was unbelievable. Well, the problem that I have from a policy standpoint is the emergency rules, when created, were not consistent with the current state statutes. And our rules are supposed to be consistent with former statutes. At that time, the former statutes before the emergency rules were created allowed adjacent landowners preference. It would allow those landowners the opportunity to be able to at least bid on that or match those bids, is my understanding of the statute. The emergency rules were created with strictly the idea that whoever bid the most got it, with no regard for whether or not that landowner had adjacent lands or being able to use it or anything like that. And then after the emergency rules took place, we went back to the new rules now that are established that were very consistent with the previous statutes. So in that determination, my goal here is to try to figure out a way that we can make our policies and to be able to do regulations through the agencies that are more conducive to being able to follow the current statutes and to do, I guess, more thorough investigation of what's happening in these leases. From a district representative's perspective, it concerns me that when an agency says, and I quote, we many times allow natural selection to straighten out these leases. We'll lease this and we'll let these folks work it out. The problem I have is I have a sheriff now and I have current landowners that are in actual danger, I believe. I have talked to the wife of one of the leaseholders, the former leaseholders. She fears for her family's life that they would run into the leaseholders up there on the land. And we've got animals that are being gathered, sent over onto other leases. And we also have the issue of a federal lands or Forest Service, which adjacently borders this state land. And that's a completely different ball of wax. And so now we get into a situation where does the state of Wyoming have a responsibility to fence? And that's sometimes clear, sometimes not. And so I guess my question to the committee would be, and my ask of you is, can we please look through this, hear the testimony? I'm sure Mr. Crowder is going to give the state's position. But at this point, I believe there should have been more oversight, more personal involvement and understanding of the situation, the problems it would create, and waited, like many other leases were given the opportunity, as I've learned after the fact, to be decided after the new rules to govern this and the emergency rules were passed and the new rules were created. The decisions were made at that time and saved a lot of heartache. So my concern is for my constituents. My concern is for my law enforcement that are being put in very difficult situations. And that I think this could have been handled better. And we need to, as a body, look at our policies and make sure that we can avoid this at all costs and try to change what we do and how we manage this going forward. Thank you, Madam Chairman.
All right, thank you. I do have one question for you. If the emergency rules were not consistent or based on statute, where was the authority to act coming from?
Madam Chairman, I'm sure that's a question that will be able to be answered hopefully by the state lands, but in my understanding, and Sheriff Hodge can probably clarify this, in the discussion we had, is that the emergency rules were created to try to take care of issues on about 140 some different permits to help them to be able to try to work through some of the issues that they were having with those permits. And my understanding is that after those permits were cleared up, then they went back to the other rules. Well, and I don't know how deep you want to get into this, but I think, well, I was actually elaborated by one person that the emergency rules were created to take care of a situation on a permit there near Douglas. And then to try to work through that situation that they had with the Wagon Hound. And then this just so happened that this transaction or this land deal happened on my constituents and they were basically thrown into the mix at that time. I guess what kind of concerns me is I've done some more research and looked at, and Sheriff Hodge can also follow up on this. There were other leases that were being considered at that time that were given the opportunity to be able to be temporary or held over until the new rules were created and promulgated that were very similar to the previous rules, to the emergency rules. And then those determinations were made. I want to know why as a group or why as an office that we would push this one through and allow others the opportunity to be able to wait till the rules were promulgated that would be more conducive to allowing the state to be able to protect its fiduciary responsibility to the lands, which means that the landowners would have the right to match that bid. So the state would not be short of any dollars ultimately, but to give preference to folks that were not going to be put in a difficult situation if you're an adjacent landowner or something like that, to try to cut down on the amount of issues and problems and avoid natural selection in my mind.
All right, questions for our good sheriff or Representative Nyman? Any questions, Senator Cole?
Yeah, thank you, Madam Chairman. Just a question. It seems like there's two issues here. We've got one where you apparently don't have the tools you need to diffuse a situation, because you say it's a real bad situation, Sheriff. So that's one thing. Then we got the OSLI, something happens with a lease and it doesn't work out right. And you're stuck with the situation, if I understand how the story goes, where you feel it's going to escalate and turn into something probably violent. And so there's nothing you can do, you and the county attorney, to charge this person for threats, or they're within their rights to make these threats. I mean, I'm a little confused about why that can't be handled. And then the second part would be I think I know enough about the OSLI situation with the leasing, but I'm concerned that you don't have the ability to deal with a situation like this. So could you maybe explain it a little further? Thank you.
Sheriff Hodge?
Madam Chair, to answer the question, part of the issue is we have a tit for tat situation. One of them is they're calling, but they're not threatening bodily harm. They're threatening lawsuits, get your checkbook out, just repeatedly calling. There has been discussion on whether or not we need to do harassment orders, and we've talked about that before. But that's one side of it. So we have the tools. The other side of it is we don't have the ability to give them a firm answer on the fencing issue. The inconsistencies coming from OSLI, when I have one agent tell me that it is the state leaseholder's responsibility to fence, that's his responsibility. And then the interim director tell me, no, it's not. It's a trespass issue. So the inconsistent communication coming from OSLI puts us in a difficult situation where we can't just go to one of these ranch owners and say, this is the way it is. This is how it needs to be done. It puts us in a precarious position where we're basically just doing civil standbys or keep the peace before something does happen. Does that answer the question, madam?
Follow up?
Madam Chairman. Yes, sir. Thank you.
Okay, all right. Any further questions? Any further questions? Okay, I don't see any further questions. I see Interim Director Crowder has stuck around for this issue. If you'd like to come up and the two of you can stay there. You're just fine. There's plenty of chairs. And maybe we can just get some answers for you and try to get to the bottom of some of this. Welcome back. I'm sure you've heard the questions and maybe you could help us find some answers.
Thank you, Madam Chair. Jason Crowder, Deputy Director for the Office of State Lands and Investments. I think there were a lot of questions asked just now, and it's a very complicated issue, so I'm happy to go in any direction that you want. But I do want to give the history as well from the office's perspective. And it's a little bit different than what the sheriff provided, so I think it's important context for the committee to understand. Obviously, the board did acquire as an investment the Mosque property in early 2020. And throughout that process, we held public hearings and public comments and understood that there were existing users of that private property before the board acquired it. We also understood that if the board were to lease it for grazing, it would have to follow the existing statutes for vacant land leasing, like the sheriff mentioned, and go through that process. And that's a fair process for all involved. It has no preference for historic uses. It has no preference for adjacency or anything like that, like the sheriff mentioned. That at the time was not present in the vacant land leasing rules. Now, obviously, the legislature took action and changed that and gave preference to adjoining landowners. But that wasn't present at the time. And the committee may remember, there's been a lot of conversation about how the office was to lease vacant land. It went through a couple tries to pass legislation to give us a more clear process to make sure everybody knew what the rules were. And it passed a bill that was ultimately vetoed by the governor at this time to give us that guidance. However, we had acquired this property in early 2020 and had users of that property that we felt we needed to get under lease. There's some very important reasons to get those people under lease. One is that they can make monetary investments into their lease. If they only have a year permit, a temporary permit, they don't have the security to put fences in to further the water development in the area, to make other financial plans for that property, because it's just not a sustainable situation. It's temporary in nature, right? So when we acquired the property in 2020, we honored the existing prior leases that were on the property when it was private. Now, the previous leaseholder, or the previous owner, sorry, did terminate all of those leases. He sent notice to every single leaseholder and said they were not to rely on that use the following year. But we stepped in and did honor that use for the following year. And we gave each one of those existing users a 1-year temporary use permit for grazing and told them during that time, we would understand what the best situation for the grazing use out there would be, where various units for different grazers could be, if it was the same as it has always been, or if it were some other different type of mixture of grazing units, but would allow those people out there and anybody else who wanted to bid on the property to tell us what that would look like. When we offered the land for lease under the existing grazing premise, and the sheriff's correct, that was done under emergency rules. And I'll just digress a little bit to explain what the emergency rules were. As I mentioned, the legislature did try to give us guidance. That guidance didn't pass the governor's test. And so we were left with what the rules were, or the law was previous. And it was to lease vacant lands in a way that inures to the greatest benefit of the trust beneficiaries. And the way we had always done that is by highest bid, that we believe that to inure to the greatest benefit of the beneficiaries. One thing that came out of all of the discussions in the legislature with the Board of Land Commissioners when we were developing the vacant land leasing process was that there wasn't a clear definition of preference. Was it an adjoining landowner? Was it the highest bidder? Was it the previous user? That definition wasn't there. So what the emergency rules did do was define that preference. And it defined the preference as those who bid the highest amount, as I recall. And again, I'm gonna miss on my dates. I'm gonna miss on my extreme explicit facts because I didn't bring all the information for this topic with me to this meeting. But that was what the intent of the emergency rules were, was to clearly define the preference as the office had historically used it, not just in the previous year, but historically 20, 30 years prior to that. And that's how we offered the land for lease under those emergency rules.
Can I
We
ask you a question right
Yes, ma'am.
there? All right, so if we hadn't passed the law and you define preference on your own, where did that authority come from to do that?
Madam Chair, that's a great question. The authority came from the Board of Land Commissioners. So inside 36.5.105, there is a vacant land leasing process that was there historic to any action by any recent action by the legislature. We had operated vacant land leasing under that authorization. And when the governor vetoed the legislature's attempt at a process, we went back to that. But the board said, I will not only go back to that, but I need you to define how you're using preference. And what they approved was a historic interpretation of the word preference.
All right, thank you for that.
So when we offered the Mosque property for lease, we split it up into the 5 historic units that were previously used for grazing and let anybody, according to the vacant land leasing process, bid on those properties under that definition of preference. We received various bids, numerous bids on that property, exceeded our revenue expectations, which was a positive thing from a beneficiary standpoint. But also it did change the users of that property. The existing users, the majority of them did not bid as much as the new users coming in. And under that vacant land process, what we determined to inure to the greatest benefit of the beneficiaries was the highest bid. And so we did issue director's decisions on those leases that had 2 or more bids, which I believe every single one of them did. And then provided an appeal period for 30 days. Numerous ones were appealed. They went through the Office of Administrative Hearings process, and every single one, the director's decision was upheld, that it did meet the muster of the emergency rules. It met the muster of the statute in place at the time, and that the director's decision was appropriate. So we ultimately issued those leases pursuant to those director's decisions. So maybe I'll pause there because that is the history and the how we acquired and got the leases on the ground.
All right, well, I have another question because I'm a little confused about the temporary use permits. So the historic person who'd had the lease when it was private property, you issued a temporary use permit for a year, is that correct?
Correct.
So one, if they had a temporary use permit, that doesn't give them any preference as far as going forward. So you're shaking your head no on that.
Madam Chair, and just to clarify that, they would be considered an existing lessee if they held a lease. That would be granted the preferred right to renew and match any conflicting bid that came in. But since they simply held a permit, they weren't granted that preferred right to renew because they were not a lessee, they were a permittee.
Okay, but then the next time when you're looking at giving the other people the temporary permit, you didn't want to do that because of fencing and all those other issues. So what made the difference between the new person that you were leasing to and the one who had historically been there? Why did you decide to make one a permittee and one a lessee?
Great question, Madam Chair. It was simply to allow the office enough time to work out a different solution for grazing, and more importantly, to allow the legislature and the board to provide us with a vacant land leasing rule and process. If you'll remember, during that time, the board did put a moratorium on all vacant land leasing until that process was provided to the office. So as Representative Nyman mentioned, we had a backlog of 140 leases that were not put in the process because of that moratorium, awaiting the process from the legislature and from the board. So that's what we had in front of us. And to be good neighbors and to understand that we needed those things to fall in place, well, we also needed continued use of the property. We did grant the 1-year temporary use permit for grazing for those existing users to allow those things to fall in place.
Okay. All right, any further questions before we go any further? Senator Ide.
Thank you, Madam Chair. Just a quick question for Deputy Director Crowder. Are you the new director or are you still the deputy director?
Madam Chair, I am the deputy director until Monday, and then I believe I'm the interim at that point.
Thank you. What was the reason the state acquired those properties in the first place? I guess I haven't heard that or I missed it. Thank you.
This is my favorite question. Thank you for that, Senator Ide. Madam Chair, the state was provided an opportunity to partner with varying groups to acquire the Mosque property. It was offered for sale by the previous owner for quite some time, and his intent was that it stay somewhat pristine, separated from development. And so his first intent was not to sell it to a private individual, but try to get it into an entity like the state or some other conservation situation where it wouldn't be built up into houses. He worked with the Forest Service and our forestry division through their legacy program to seek Forest Service funds for acquisition of the property. That's one of the outcomes of that Forest Legacy program. We partnered with that, brought in $6 million from that Forest Legacy program. The State Loan and Investment Board invested $4.1 million in the acquisition. We received another, I get these numbers a little wrong, $200,000 from the Wyoming Elk Foundation, and then a little bit of money from the Turkey Federation as well, all brought together to acquire the Mosque property as an asset of the state. So the board only put in 4.1 million of the total $11 million acquisition costs, but receives 100% of the revenue that comes off of that, not just through grazing, but we're anticipating some recreation as well as the timber resource that's there.
Did you have a follow-up?
Quick follow-up. Thank you,
All right.
Madam Chair. How many total acres are involved in this? Thank you.
Madam Chair, Senator, just over 4,700, I believe.
All right, any further questions? Okay. All right, so Sheriff Hodge, did you have any further comments?
I do, and maybe Deputy Director Crowder can address this, but in 2000, I have the 2019 statute here, 365105. Criteria for leasing preferences, assignments, subleases, in lease and vacant lands, preference shall in all cases be given to applicants who are bona fide residents, citizens of the state qualified under provisions 365101, and to persons or legal entities authorized to transact business in the state, have an actual necessary use for the land, and who are owners, leases, or lawful occupants of adjoining lands who offer to pay an annual rental of not less than fair market value. That's the 2019 statute. So I think that's where maybe we're confused, but the rule should be consistent with the statutes. And this says in all cases be given to applicants who are lawful occupants of adjoining lands.
All right.
Thank you, Madam Chair.
So that takes us back to why the emergency rule it doesn't sound like it was consistent with state statute.
Thank you, Madam Chair. And this is the exact reason why the legislature needed and wanted to take action, as well as the Board of Land Commissioners, because there's some ambiguity in there. What the historic interpretation of that whole statute, not just subsection B, but subsection A. Subsection A states in all cases, leases shall inure to the greatest benefit of the trust beneficiaries. And then it says in all cases, vacant land, the preference shall be done here. So we had a couple conflicting in all cases. The way the office had historically interpreted that was if in all cases there was a high bid, then that inured to the greatest benefit of the beneficiary. However, if there were two conflicting bids, both equal, both inuring to the greatest benefit of the beneficiaries, we use subsection B as a tiebreaker. And that's truly what the emergency rules explain. And thank you for bringing that up. But that's the interpretation that was historically used by the office. That was why we needed help from the legislature to clarify the conflicting in all cases, the two in all cases, and how the emergency rules were developed to clarify that interpretation.
All right, so then after all of this happens, who has the duty to fence out? Because now we've got these conflicting boundary and border lines, and what is the state's responsibility in that?
Thank you, Madam Chair. And I do want to tell the committee here that we have provided guidance to the sheriff. We've submitted him a letter, which is our position on how this situation should be handled. So we feel we've given him clear guidance. How he uses that is obviously up to him. In our mind, there's nothing in state statute that talks about fencing state land. And then inside the fencing statutes, there's a little bit of unclear definition of what a landowner is. Is that us, which we don't feel it to be, or is that the user, the lessee? And that's historically where the burden has been placed, is at the lease level, because they're the ones managing that property. They either manage it all by itself, they manage it separate from the adjoining landowner, or they manage it in concert, collective with the adjoining land, if they have the federal permit or if they own the private land. But that's left to them to understand what best management scenario needs to occur to place the fences in the right place. What is present in state statute for state land management is a simple statute, and I forget the number, the sheriff probably has it in front of him, but it talks about trespass. And it simply states, if you don't have a lease or an active permit, then you will be defined as a trespasser if you're on state land. It has nothing to do with fence. There's no fence in, fence out. It's if you're on state land without a valid lease or a valid permit, then you are defined as a trespasser. And that's what we explained inside of that letter. The people on the ground need to decide what best fits to keep them out of a trespass situation. And if that's fencing, great. And the type of fencing, of course, is varied across the state. In fact, we have new technologies of remote fencing or GPS collars or something like that. All can be utilized to keep one party from being defined as a trespasser in that situation.
Okay, Representative Banks.
Madam Chairman, thank you. So what I'm hearing, I think, is that the office doesn't want accountability. They want the problem to be solved, which it's not the problem of the property owners. It was a problem created by the office. I want to know what accountability comes back to you of how you address this problem, besides just saying, basically deal with it yourselves. I think that's what we want to know as the committee. What's the accountability? What's the responsibility of the office in this situation?
Go
Thank you,
ahead.
Madam Chair. I believe the office's responsibility is to follow the rules and the statutes that it's provided. We organize our leases. We let those leases be given pursuant to the process given to us. And that's our responsibility to uphold those laws. If our lessee is trespassing or moving off of the state land onto somebody else, he is not in violation of his lease. He is not in violation of any rule or any statute specific to state lands. If there's somebody off lease is coming on to state lands without a lease, he's in violation or could be defined as a trespasser pursuant to that statute. Those are the laws that we have in front of us. And that's our responsibility, is to ensure everybody knows that, and that we manage our lands pursuant to those statutes. Now, I do want to make one clarifying statement. This is an extreme solution. We have never used that trespass statute to its ultimate end in my recollection. Every single situation that comes up, we've been able to mitigate through conversations. It might escalate to a violation letter or at least a notice letter, maybe even a letter from the AG's office, but we've never gotten to the point where we actually had to define somebody as a trespasser and issue a citation or ask the authoritative body to issue a citation. We've been able to have those neighborly conversations and reach a resolution before then. And that's where I think we are in this situation, is trying to see if there are other mechanisms before trespass that can be utilized to correct the situation. And some of those have been unfruitful. We've tried the mediation program through the Department of Ag. That doesn't seem like it's going to bring us a positive result, but we've attempted it. If there's some situation where our existing lessee can no longer use it or no longer wants to use it, he can assign that lease to just about anybody he wants to. Or if the adjacent landowners have some need for it and want to sublease from him, he can do that as well. And those are mechanisms that we probably haven't fully vetted out at this point. As the sheriff mentioned, this is a very heated topic, and so we are involved in it, but we don't want to create a situation where the state of Wyoming is instituting a management directive on these individuals. The legislature's never put us in that position, and we really don't want to be in that position because we're not on the ground and we don't have the resources to be on the ground and to create those management solutions for them. The best solution is always those guys creating their own solutions, and then we make sure that it follows existing rule and statute.
Representative Craigo.
Thank you, Madam Chairman. I was just going to ask the sheriff or Representative Nyman if you could provide me with a map. I mean, I would love to be able to actually see I think it would help all of us just to see it on the ground and see what we're actually dealing with. I mean, I think we got the basic gist, but I'm a visual learner. So I would love to, if you have one, to be able to see it.
May I
Sheriff, go
approach,
ahead.
Madam Chair?
Yes, go ahead and start it at that end and we'll pass it this way. That's a good, thank you. All right, Senator Cole.
Thank you, Madam Chairman. Well, almost interim Director Crowder. Seems like you do have the tool. I mean, from what you just said, you can issue a trespass to somebody who's trespassing on a lease. So I guess the first question is why, you said why you didn't want to do it. I mean, I get it, but would you rather have somebody get hurt or God forsaken killed? I mean, this is obviously bad. And I guess, what is it going to take you to issue this order of trespass? I think that may be a tool that could be used in this case, whether you'd like to do it or not. I understand that, but what threshold does this have to cross before you take action on this? Thank you, Madam Chair.
Go ahead.
Thank you, Madam Chair. Senator Cole, that's a great question. I think we are rapidly approaching that point. With what the sheriff has described to us and in other meetings in Cheyenne, it's a very important and likely emergent situation that we need to respond to. We wanted to make sure that we deployed as much of the other tools as we could beforehand. And I think the most important one is the mediation tool. That has just recently, within the last week, likely not, or shown that it likely won't reach a positive solution. So it could be that one of the next steps in the following week is to approach that letter of identification of trespass.
Representative Craigo.
Thank you again, Madam Chairman. So I guess I'd like to know the statute number that allows for the trespass to be issued, and does it require intentionality? Do you have to intentionally trespass? Because I would I'd venture to guess that the neighbors are going to say, well, I didn't tell my cows to go over there. They just wandered over there. And that's going to be real hard to prove intentionality if it's an element of that particular statute. Maybe the sheriff can tell me the statute number. I'd like to look it up.
Madam Chair,
Go ahead.
Wyoming statute 36-9-116. And may I talk a little bit, Madam
Yes,
Chair?
go ahead.
The other issue we have here is it borders federal property, and the federal law that has been gone through federal court numerous times. The Forest Service and federal property they do not fence anything. So are we trying to mandate that the forest lease people fence their cattle out? And I think that's been pretty well resolved in federal court that that's not going to happen. So yes, there may be a trespass statute, but does that trump federal law where it says they're not responsible for fencing out cattle coming in or fencing cattle coming off? And they also have their own trespass statutes also. So I don't think the trespass statute applies to this.
Okay. Well, we're circulating the map. We have lots of things flying around in the air too, but I guess to me, the thing I'm struggling with is okay, the state buys this piece of property. There was no fence there to begin with. We don't allow the person who was historically leasing it to lease it, so we bring in a new leasehold. And then we are saying, now all of you have to fence your cattle out of here that have been running here for a long time. And we're gonna charge you with trespass if you get on our land now. And we're not taking any responsibility for the situation is what it sounds like to me. Now, if I'm misunderstanding that, please let me know, but it's a difficult situation. And I want to know what the state's responsibility is because the state made the decisions that created the situation.
Thanks, Madam Chair. And it's a great question. And I think hindsight is always 20/20. I'm not sure that we could have made any different decision or taking any different action, but we can certainly see the impacts of our decisions collectively through the vacant land leasing process that was provided, what they have to today. The only thing I want to add to what you just mentioned was that the existing people or the historic users of that property had the exact same opportunity and they did participate in the process as everybody else. They just simply didn't bid as much as the guys who ultimately were awarded the lease. So they weren't held out of anything. They weren't granted any other higher benefit than anybody else, but they weren't given any negative benefit or treated any differently than anybody else.
Right. And it's been a while since I've looked at this, but I thought somebody who had a lease had the ability to come back and bid again if somebody else bid higher than they did.
Yeah, Madam Chair, now they do. The legislature was able to pass the new process that we currently abide by, and that is it.
Okay. All right. Sheriff.
Madam Chair, so under the emergency rules, should the attributes of section CI and CII be equal as determined by the director shall request a final bid from the conflicting applicants at a live auction. That never happened. And that is in there, the emergency rules that took place during that time. And it says qualifications of applicants under provisions 36.5.101 rental offered. So none of those added up to equal. Basically, it was just highest bid. And my opinion on if the state's going to go with this, it's just allowing the big dollars to come in and push our small ranchers out. I mean, there's supposed to be a percentage, and if I understand right, they all bid within the 120% appraisal rate. Is that correct, Deputy Director or Madam Chair? Can I ask him that?
Yes, this time we'll allow it, but so there was a bid process, auction process in the emergency rules for conflicting bids.
Madam Chair, I don't have those rules in front of me. I don't believe there was a version, yes, that did have that. I don't believe that was the ultimate approved version of the emergency rules, but I'm happy to go back and research that for you. The only other thing I would offer is that all of these directors' decisions that were approved or made during the emergency rule period were tested by the Office of Administrative Hearings, and they were upheld at that time. So they did follow the rules that the administrative hearings used when they were reviewing the director's decision.
So, Mr. Crowder, what is our responsibility now that we do have 20/20 hindsight and we have the situation going on? I mean, what is our responsibility?
Madam Chair, and I'm happy to seek any input that the committee has or really anybody else to reach a resolution, because that's what we want. We do understand this is an important situation up there and that the parties are not happy and they're not reaching a resolution like we would like. So any input would be greatly absorbed. But I will say that I think our obligation is to ensure all the tools already available within state government are deployed in this situation. That would be mediation. And if we have to get there, all the way to the trespass statute that we talked about.
All right. Okay, Representative Slagle.
Thank you, Madam Chair. Mr. Crowder, I guess the question I have, earlier you said that you didn't believe the state had ownership of that land, but previously you just told us the state had acquired it. So I consider that ownership. And you're the ones, if you have ownership, are responsible for fencing out. So when you lease that place out, you said you got a higher lease rate. So therefore you have the money or have more money. You should be able to afford to fence that state section out. I mean, or else require whoever's leasing it to fence it out. And I mean, I guess I really see this as a fence out issue, and the state should have to follow the same laws that I have to do. And everybody else that has land, we have to fence people out if we want to keep their cattle out. And the state should have to follow the same thing because you are the landowner. Thank you.
All right, so we're, Senator Cole.
Madam Chair.
Thank you, Madam Chairman. Just a question, Director. Is the other party amenable to potentially, I guess, buying out the lease? I mean, has anyone gone down that road to ask that question? Is there any, what's our direction forward? I mean, how are we going to resolve this? We've got an obvious disagreement with people that seem unamenable to a solution. So maybe, is there anything you can do for the lease period that is left to try to defuse this besides trespass orders? I mean, what are your thoughts on that, Director?
Thank you,
Go
Madam
ahead.
Chair, Senator Colvin. And we have thought about those. What are the other things we could try? One is to buy out the lease, and that is a provision within the lease that we could utilize, have never utilized it before, and certainly haven't ever contemplated taking one lessee out of its leasehold and then providing that lease to a neighbor or to somebody else. We just haven't ever been presented with that situation and don't feel like that's a good honor of the contract we have between the lessor and the lessee.
All right, go ahead. Follow up.
Yeah, follow up. I would agree with you under most circumstances, almost interim director. But I think under this circumstance, we have a statutory change that happened. And that is what makes this different and unique. That's why I think it would seem like a path forward. I think you got to think outside the box in this case. And yeah, you may have never done it before, but when have you ever been in a situation where the statutes actually changed from what they were to emergency ones and now permanent ones? So let's get everybody on the same page. Thank you, Madam Chair.
All right, I think, go ahead. Before we have one more question, I just want to let everybody know, because of the lightning strike at the school, we were squeezed into this location and we have to be done by 4 o'clock so we can clean everything up and there can be no trace of us by 5 o'clock. So I'm just saying, it's not me, but it's, the community has been exceptionally gracious to host us and move us around because of this act of God. So blame God if you have a problem with it. So, Mr. Co-Chairman Eklund, go ahead.
I'll be real quick. Several of us here are used to solving difficult problems. This one, just looking at the map, makes it very difficult. And I can see why the remediation probably didn't happen. It'll take more than this meeting to solve things. There's a lot of questions I would have as to, does the Mosque unit separate one guy from his pasture over here and his pasture? I don't know any of that, but it'll take a while to sort it out. And is there a good solution? Probably not. We just, unfortunately, the vacant land legislation didn't go through the pipe like it probably should have, or we didn't get it right. It wasn't tight enough or something. I can't even remember why it didn't, but anyway, there's a lot of questions that we're not going to have time to answer here. And I appreciate your bringing it. I hope, looking at it, God bless you as you go. I hate to do it that way, but as you enforce the law there.
Sheriff, would you like to bring us home? And
Yes, I'll quickly answer his question, Madam Chair. Yes, that piece of leased land separates his federal lease from his private property. So no matter what, he's going to have to go through that state lease to even get off. That's their access into some of that federal property. There was a Forest Service employee that was on standby to testify. Obviously, we're running out of time, and maybe if we decide to push this thing onto and have more. I'm pleased that you guys allowed us to come here and discuss this, and I'm hopeful that we can come to some type of a conclusion. My opinion is OSLI kind of created this because they were aware and were told, I believe Senator Driscoll testified, the county commissioners told them, Representative Nyman told them, and a lot of other people told them, do not do this. The impossibility of fencing some of this is going to create these issues that they're all coming to light now. So the oversight of OSLI on this is what is driving this. I don't know of any mediation that's being taken place by either parties, and we're in contact pretty much weekly with both parties on this. I have not heard of one testimony from either one of them that the state has contacted them for any type of mediation process. So,
Okay.
but once again, Madam Chair, committee, thank you for allowing us.
Yes, and Sheriff, if you have someone on Zoom on standby, I wasn't aware of that. He's welcome to testify if he's there. Did you say you have someone on standby?
Madam Chair, the Forest Service was just on telephone unless the county attorney is on Zoom and he wants, that would be
Do we
the
have
only other
anyone?
person I know of.
We don't have anyone. All right.
Oh, okay.
Well, then let's stay in touch on this. Representative Nyman, obviously we'll stay in touch. If you have solutions where we can be helpful, we would like to be. Same with the office. If there's something we can help you with to help resolve this, we're very well in tune with this issue as we've dealt with it for many years now. So, with that, we will take any other. Senator Hicks.
Madam Chairman, if you'll allow me a little indulgence to digress on the issue of the trespass issuance by the Office of State Lands, I think this committee would look very fondly on the issuance of trespass to the issue that we addressed yesterday was the issue of federal feral horses all over our state lands that are causing destruction. So I would strongly encourage you to probably issue that trespass notice sooner than later. Mr. Acting, soon to be or permanent director of the Office of State Land. So won't hurt anybody's feelings on this committee in that particular instances. So we look forward to that issuances in the near future.
And that seems like an appropriate note to end on. But before we end, we will see if there is any public comment. But thank you, gentlemen, for making the trip and bringing this to our attention.
I want to thank Madam Chairman, Mr. Chairman, and all the committee for taking the time and giving us the opportunity to be able to share this with you guys. And we look forward to working with you and quite frankly with state lands to try to resolve this so that we can do good things for people going forward. But I do believe there's a lot of room for improvement here and how we handle our permits. And so we can avoid many of these things that we're dealing with right now. Thank you all.
Thank you. Thank you, Representative. Is there any further public comment on any issues that we've dealt with the last couple of days or anything we need to be aware of from the public? Seeing none, is there anything that staff needs from us? Anything that we haven't cleared up? Anything that is unclear? No. Anything from the committee? Anything that you would like to deal with before we adjourn? Seeing none, we are adjourned. Don't forget the tour tomorrow at 9:30. If you're staying over, safe travels, and we'll see you in November. I do think we may want to look at maybe changing the date from the voting day if we can, but if not, you will have to get an absentee ballot and vote and then come to work. So in November. Otherwise, you'll be purged from the voting rolls. Okay, thank you, everyone. We are adjourned.